So the issue of your dismissal, which you contend is unfair and unlawful, that we've dealt with, that's out of the way. You say there's still a Labour Appeal Court decision that's pending.
Yeah, I thought, Chair, we must move away from that one by allowing me to close it with these paragraphs which are in that particular portion, and then we can go to the 360 that you were making reference to, without going into the details, whether it is the arbitration or the Labour Appeals Court. And somewhere I think me and Counsel are talking past each other, because unless I have it wrong, you talked about the arbitration. Now, there are two arbitrations. There is an arbitration award that relates to the 360, that led to the payment of the 360. And there's a triple SBC, award. Now, that award, the Labour Court judgment, is a subject of the current pending matter before the Labour Appeals Court. Therefore, I don't think I will want to go too much into that. We have said a lot. What I will talk to is the arbitration award, the Judge Haramse arbitration awards that relates to the 360 and the awarding, the subsequent payment of the 24 million. But I thought maybe just to close off the issue on the dismissal, just to sum it up, if I'm allowed, to refer to those paragraphs in my affidavit.
Yeah, you may do that if you enter it, but I just thought that I agree with you. And just for purposes of clarity and to honourable members of the committee, we are talking about the same tender. That's the 360-degree camera. But in relation to the one arbitration award, which involves your dismissal, that is your conduct in relation to that tender and that contract. Then there's the other award of Harms, LTC Harms, the appeal judge, retired, where he confirmed the payment of 24 million. The tender itself, the 360-degree camera tender itself, is worth over 90 million. The arbitration award of Harms was when there was in inverted commas, settlement agreement, which did not involve you at all. And that is also the nub of your complaint. You were not consulted, you were not asked. It was actually a settlement agreed to by National Commissioner Sithole.
All right. I think this is where now I'm very calm and I'm going to relay the facts so that the disinformation is not continuing. Counsel just referred to 92 million. Haramse's judgment has got nothing to do with 92 million. Yes, 92 million is the bid, the same panoramic contract bid camera, the 360 cameras, forensic services. When the contract was awarded on the 28th of July 2014, the value of that contract was 92 million. Now, it gets awarded. Once it is awarded, obviously, my environment, forensic services, is the end user, because these are cameras that are used by crime scene experts. So ordinarily, we are to place an order and buy from that particular contract. That contract is awarded to a timber. So before even we can place an order, a competing supplier, who in this case happened to be FDA, writes to supply chain management as a division, the place where contracts are being managed. They are the ones who awards and so on the contract. So they raise an issue with supply chain management, wanting to inquire on which basis was the bid awarded to a timber, because at least them being in the industry, they knew what the camera offered by a timber specifications are versus what camera they were bidding for. They responded to the bid for. So once they raised the issue with supply chain management, I think the letter of FDA, which is part of the records, was the 22nd of August, 2014. They now, supply chain management, instead of them dealing with the complaint, they opt to send it to me in forensic services. When I received that complaint, which is an issue raised by FDA, I then put together a team of experts, the same managers, the same team that compiled the specifications. I put them together to say, here is an issue where supply chain management is requesting our input. So they revert back to me and say, indeed, they have looked at the specifications against the product that is offered by a timber, and they concluded that that is not compliant with the specifications. In other words, supply chain management awarded to a bidder who did not comply with the specifications. I then write back to supply chain management to provide them with that information, to say, you have awarded a contract to a supplier, and we are not going to be able to use these cameras because they don't meet specifications. And Counsel, you're correct. That contract is worth 92 million. So there was to and fro in terms of communication. We said to supply chain management in my letter, which is here on the records, 22 October 2014, go into a process cancel. When we say cancel, we don't mean you must just immediately receiving our letter cancel. They must go together with legal services into a process of engaging the supplier and say, we have established the following. The issue there was that even the bid evaluation committee, when they made their submission to the BAC who awarded, they did indicate the non-compliance by the timber bid. Heavens knows why that contract was awarded, because the BEC is saying to you, this product does not comply with this thing. For example, one of the requirements was it must be a 360 camera. It must not allow manipulation. You must not stitch images together. But the timber product, you stitch, you do 90 degrees, 90 degrees, 90, which is, you now piece together the 90s to make it 360. Now that is unacceptable. You can't go to court and present such evidence, because the chances of the courts and learned friends arguing, but you have manipulated, and they are great. So that thing has got no value. Now, long and short, consistently as forensic services, we have given feedback to supply chain management and say, we can't. Supply chain management went even to National Treasury to say, how do we deal with this contract? National Treasury comes back to them and say, subject this contract to an independent assessment. That time, I'm acting national commissioner. The supply chain management and legal services write a note to me. It is here. I think it's JKP4. In the submission, they say, can we take it for an independent assessment? 23 November 2016, I agree and say, take it for an independent assessment. I think also there is an email here where the same supply chain management people communicate within themselves and say, the acting national commissioner said we must defend the litigation take it for independent assessment. But I can tell you that today it is not dealt with. So when we talk about 92 million, you are not talking about 92 million in respect of Haramse. You are talking 92 million in respect of the July 2014 contract.